A major legal battle over the National Firearms Act has reached a critical point. The United States Supreme Court is now showing interest in a case that could have sweeping implications for gun laws across the country. The case is United States v. Rush, and it challenges the constitutionality of the NFA's restrictions on short-barreled rifles, or SBRs. What makes this development especially important is that the Supreme Court has just asked the Department of Justice to respond to the petition in this case. Originally, the DOJ under the Trump administration waived its right to respond unless the court specifically requested it. Now that the court has issued that request, it signals a genuine interest in hearing the case, and that's a significant step. At the heart of the challenge is the argument that the NFA's regulation and registration requirements for short-barreled rifles are unconstitutional. The petitioner, Mr. Rush, is asking the Supreme Court to declare that these restrictions violate the Second Amendment. His legal team also wants the court to step in and provide clear direction to the lower courts, which have been inconsistent, and in some cases resistant, in applying the Supreme Court's guidance from the recent Bruin decision. This case also comes at a time when lawmakers have moved to eliminate the $200 tax on items like suppressors, short-barreled rifles, and short-barreled shotguns, adding even more pressure to re-examine the legitimacy of the NFA's remaining provisions. If the Supreme Court rules in favor of Mr. Rush, it could lead to the dismantling of key parts of the NFA, including the Federal Registry itself. Now, the central question presented to the Supreme Court in this petition is whether the Second Amendment protects the right to possess unregistered short-barreled rifles that are in common use for lawful purposes. In his petition, Mr. Rush argues that ever since the Supreme Court issued the Bruin decision, lower courts across the country have struggled to apply the court's new framework for evaluating Second Amendment cases. One key area of confusion has been over what qualifies as a bearable arm, protected by the Second Amendment. This case directly addresses that issue and presents an opportunity for the Supreme Court to bring clarity to what types of weapons fall within the scope of Second Amendment protections. Importantly, while this case does focus on short-barreled rifles and the arbitrary restrictions placed on them under the National Firearms Act, it also aims to prompt a broader clarification from the Supreme Court about the kinds of firearms the Constitution protects. That could have far-reaching implications, impacting ongoing debates over state-level rifle bans, magazine capacity limits, suppressor regulations, and more. The petition argues that the Second Amendment protects all bearable arms, including short-barreled rifles, particularly when they are commonly owned and used for lawful purposes. It directly challenges the Seventh Circuit's position, which claimed that short-barreled rifles do not qualify as protected arms under the Second Amendment. To support this claim, the petition cites data showing there are over 532,000 registered short-barreled rifles in the United States. The NRA, which is one of the major backers of the petition, criticized the Seventh Circuit for ignoring the evidence of widespread lawful ownership. According to the petition, these firearms are clearly in common use, which strengthens the argument that they are constitutionally protected. At the conclusion of the petition, the request is straightforward. They are urging the Supreme Court to grant review of the case, resolve the conflicting lower court rulings, and finally provide guidance on how the Second Amendment should be applied to short-barreled rifles and possibly other types of firearms as well. Now, as previously mentioned, the Trump-era Department of Justice initially waived its right to respond to the petition. In other words, they said they wouldn't file a response unless the Supreme Court specifically asked them to. Well, that's exactly what happened. The Supreme Court has just issued an order requiring the DOJ to respond, and they must file that response by September 2nd. This development is significant. If the court had no interest in this case, it could have allowed the DOJ's waiver to stand and simply denied review after the September conference. But instead, the justices are now requesting formal arguments from the DOJ, signaling that at least some members of the court are giving serious consideration to the issues raised in this case. It's a clear sign that the court is paying attention, and it brings us one step closer to possible Supreme Court review of the NFA's short-barreled rifle regulations. All of this is unfolding against the backdrop of another major shift involving the NFA. Thanks to new legislation, the $200 tax on suppressors and short-barreled rifles is set to drop to $0 starting next year. That change, part of the broader H.R. 1 bill, has already led to a surge of legal challenges. Many of those cases are now attacking the constitutionality of the NFA based on this updated tax framework. But this particular case, United States v. Rush, is already well positioned. It's reached the Supreme Court on its legal merits, and the court now appears to be showing genuine interest. This case could become the key decision that strikes down remaining SBR-related restrictions under the NFA. If that happens, follow-up lawsuits could then target suppressor restrictions and other elements of the NFA. And if the court finds SBR regulations unconstitutional, it would be much easier to argue that suppressor bans should also be eliminated under the same logic. It's going to be particularly interesting to see how the Trump administration responds now that the Supreme Court has ordered them to file a reply in this case. Based on their previous actions, we can reasonably expect them to take a similar position to the one they adopted in the Fifth Circuit during the Peterson suppressor challenge. In that instance, the DOJ argued that while the National Firearms Act, NFA, and its associated registry, covering suppressors and short-barreled rifles, are constitutional, individual states do not have the authority to outright ban those items. In other words, they maintained that the federal government can regulate and require registration for such firearms, but states cannot impose total bans that prevent people from owning them altogether. If the Trump DOJ follows the same approach here, their argument before the Supreme Court will likely be that the registry system under the NFA does not equate to a complete ban, and therefore does not violate the Second Amendment. They would likely argue that requiring registration is a regulatory measure, not a denial of the right to possess these arms. Now, this kind of argument becomes very important if the Supreme Court agrees to hear the case. If the justices accept the idea that registration itself is not unconstitutional, but that states cannot impose outright bans, then that would be a major victory for firearm owners in heavily restricted states like California and New York, where access to NFA-regulated items is often blocked completely. This is why the court's recent order matters. By instructing the Trump administration to respond to the petition in the short-barreled rifle case currently before them, the justices are showing a level of interest that could signal serious consideration of the issues raised. It means the case is moving forward in a meaningful way, and we may be on the path toward much-needed clarification about the legal status of short-barreled rifles and other NFA-regulated firearms. This development is encouraging, especially for gun owners and Second Amendment advocates who have long questioned the constitutionality of the NFA's more restrictive provisions. As things progress, we'll be watching closely, especially when the Trump DOJ files its response. That will give us a clearer picture of the government's current legal strategy and how they intend to defend the NFA in front of the highest court. And of course, once that response is submitted, I'll keep you fully updated on the latest developments and what they could mean for firearm laws across the country. If you found this video informative and you'd like to support the channel, one of the best things you can do is subscribe. Your support means a lot, and I truly appreciate it. Thanks again for watching.